Hello and welcome to the Disability Law Q&A with me, Martin Willemse, your host. I am a partner at the firm of Samfiru Tumarkin, law firm where we handle long-term disability denials, critical illness denials, other types of insurance denials, and employment law. Today we're having a question session regarding LTD cases or other cases that you may have on insurance, questions you may have on insurance. Ask your disability questions now, and we'll respond to them live. You can send those questions in through various social media platforms. Um, Before I start, I'll say this. Our firm handles cases throughout BC, Alberta, and Ontario, where we have offices, and other places in Canada other than Quebec and the territories. So if you've got questions on disability cases, by all means, please send them in, and I'll get through them within the next 30 minutes if I can, depending on how many we get, of course. One of the things that have come up recently, I'm not sure if everybody is aware about this, is the federal government will be bringing into place a new benefit called the Canada Disability Benefit. There's been a lot of discussion, a lot of work that has been done at the federal government level, in the House of Commons and the Senate, to put into place this new legislation. The big question for everybody, and we have had lots of discussions with non-profit organizations representing people with disabilities, is when does this benefit come into place and what does it look like? Who will qualify? What will the amount be? Unfortunately, the short answer to this is all of that is still unknown. When it was being debated at the House of Commons level, I think the understanding or the intent was to have this benefit put into place sometime next year. Whether that will actually happen is unsure. The legislation has passed. Now it is up to the federal government to negotiate with the provinces regarding the regulations. And of course, a big issue for many people would be how will this benefit impact the LTD benefits that insurance companies pay to people? So if you've got a job with an employer, the employer has a group policy, has group coverage for its employees, and you go on a claim, and the insurance company starts to pay you benefits. We know that there are certain offsets like WCP and CPPD, which is the federal government's disability plan. So if, for example, the LTD insurer pays you 3,000, CPP disability is 1,000, then the insurance company only has to pay you 2,000 because it is a direct offset under the terms of the policy, within the language of the policy. And the new Canada Disability Benefit, the federal government has said, the Liberal Party, that they do not expect that insurance companies will deduct these benefits from insurance companies' benefits, or that insurance companies will be allowed or will be taking steps to deduct these benefits from what they have to pay insureds. Having said that, that has not been legislated now. So it is still an unsure thing, and that is what apparently is happening with the provinces. It's being negotiated on the basis of the regulations. Also, the question as to when it comes into play, hopefully it will be sometime next year. We'll just have to wait. What will the regulations look like? We're not sure at this time. So hopefully insurance companies will not get the benefit of these offsets, of these benefits as an offset. And the whole intent of this is to lift disabled people out of poverty and to make sure that they can survive financially while living with disabilities. And hopefully that is what the result will be, that these benefits will not become offsets. Because the whole point of this is it is not wage replacement, it is more of a social assistance. So in terms of many policies, hopefully that will not be called as an offset. But time will tell. Who will qualify for these benefits? We don't know yet. That is also being negotiated. But as more information comes out, we will let people know what information we have to share. Okay, so I have a message from Henry. I need a WCB lawyer in Edmonton. Can you please refer me? I think there may be a referral service in Alberta with respect to, it would be a service where you can contact maybe even the Law Society to see whether there is a roster who can, and thereby they can recommend lawyers in specific specialty areas. Unfortunately, we do not handle WCB cases. We have a question from Paul. I recently sent updated medical records from my doctor for my condition. It only included the information about my disability and anything related. My insurer is saying they need to see my full medical history and are demanding my doctor send this along. Can they ask for that? And as with everything, there's never really just a black or white response. There's a lot of grey. I would want to know more information. For example, if you had, are they investigating this because of potential pre-existing condition language in the policy? If it is, you've gone off work now and they want to go back and look at your records from 10 years ago, I think that would be excessive. But we would want to know more information in order to see what the circumstances are and why it is that they're requesting your entire history. Which I agree with you. I don't think that's appropriate, but I would want to see more information. Insurance companies, under the terms of their policies, are allowed to investigate claims, and that includes getting clinical records from doctors, medical reports from doctors, to see what you've been reporting to your doctor, whether conditions have been in place before. It depends, for example, if there is a pre-existing condition exclusion in the policy, which normally comes into play if a person had been working for less than 1 year, or rather had coverage for less than 1 year. Then basically all group policies will provide that the insurance company can then investigate whether the disability is related to a pre-existing condition, and if so, they may deny the claim. That is so fact specific, and every policy, depending on the insurance company, lots of them have different language with respect to pre-existing conditions, which is a contractual term. In other words, if I said I have had depression for my entire adult life, to a layman that sounds like it's pre-existing. But under the terms of a disability policy, because this is a contract, there's a specific definition for pre-existing, which may be that if you have had treatment for that condition during a specified period of time, then it's pre-existing. But if you did not, regardless of whether you've had this condition for a long-term period in the past, that may not be deemed to be pre-existing. So it's very, very important to see what the definition is for pre-existing conditions in a policy and what the facts are, and whether the person actually did go off work within the first year of having coverage. I speak to people, I know people on my team also speak to people with respect to deny disability cases when there was a pre-existing condition denial in place, which really is a contractual denial, meaning that they've denied it based on the wording of the contract, also on the merits of the claim. And if you do have something like that, please contact us at our firm, because we offer free consultations. We can review the policy with you, we can review the denial letter and your personal circumstances, and hopefully access to your clinical records as well. So as you can see on the screen, go to disabilityrights.ca to find out more. Then we've got an email question from Paul. I recently sent updated medical records. Oh, sorry, that's the same thing. Henry says, I was assaulted at work and paid 6 weeks temporary benefits 2 years after the incident. I won an unemployment appeal but have no benefit now. If you had coverage during the period that this happened, in other words, if you had coverage when you were still employed through a group insurer, then you should look into that. If you haven't applied yet, really look into that as soon as possible, because there are timelines and policies with respect to when you can submit a claim and how long you can have what the timeline would be to submit proof of claim. Even if you're late, still submit it. Make sure that it goes in as soon as possible. And if they deny the claim, by all means, reach out to us. Sammy L says, my sister-in-law has serious effects from long COVID. Is she able to receive LTD for this? This is a good question. And the reason why I say this is, as we know, it's remarkable how time has flown by. 2020 was the year of the pandemic, and it's now 2023. So lots of people continue to struggle with the effects of long COVID, and we've had various people contact our firm who have had their cases denied by long-term disability insurers. Others have been accepted and then denied. The short answer to this question is, by all means, if your sister-in-law's doctor supports that she cannot work due to the restrictions and limitations that she has as a result of long COVID or any other condition, it doesn't matter what it is. If it is a medical condition, an illness, or an injury, and as a result of that, you are unable to perform the duties of your own occupation, then you can apply for long-term disability benefits if you have coverage. These cases, these claims, are much more focused on the functional impairment than it is about the diagnosis. Not to say that diagnosis isn't important, of course it is. But I'll use an example as well, like I said before. If somebody has depression and then they go off work, and the doctor submits a claim, an attending physician statement saying that my patient has depression, therefore they cannot work, very likely the claim is going to be denied. The reason for that is you have to outline what the restrictions and limitations are. And the same thing with non-COVID. Provide whatever evidence is available to submit to the insurance company why it is that your sister cannot work. What is the functional impairment? What are the restrictions and limitations? Be it that she may have brain fog, extreme fatigue, difficulty with cognitive functioning. All of that can be detailed. Have a submitted claim. If denied, by all means reach out to us because we speak to people with long COVID denials on a weekly basis. Julie Sky says, I've been on disability paid by the insurance company for over 2 years. I've been seeing a psychiatrist, psychologist, and my GP for my condition. They provide the insurance company with their reports about my condition on a regular basis and that I'm unable to go back to work. Can the insurance company demand that I see their independent psychiatrist? Do I have to comply? It's an uncomfortable position to be in. I understand that. Now, let's go back to basics. The disability policy is a contract, and the contract has rights and obligations and terms. One of the obligations or rights, whichever way you look at it, the insurance company has a right to have you assessed by one of its chosen independent medical examiners, if it is reasonable, I would say, and it should be with somebody who is qualified with respect to the condition. In your situation, it sounds like it is a mental health disorder. They want to have you seen by a psychiatrist. So if you refuse to do that, chances are that they will terminate your claim by saying that you are breaching the terms of the contract because you have an obligation to attend these assessments. I always say to anybody who asks me this question that it has to be reasonable. So if the insurance company has sent you for an independent medical examination by a psychiatrist and they get that opinion and then they decide to send you to another one right after that, I would say that is a problem because for them, not for you. Because then it looks like they're doctor shopping. They're shopping to get an opinion that may support that you're not disabled from working. But if it is, they haven't done this before, you very likely will have to attend. Otherwise, you may face a denial. Now, if you've got further questions about that, of course, reach out to our firm. We can discuss that with you. But be honest when you attend, respond to the questions, and hopefully the doctor supports on an ongoing basis to remain disabled. Again, as you can see on the screen, go to disabilityrights.ca for more information. Liz McGee says accommodation duty. When we can demonstrate the history in transitioning ourselves, accommodating our own needs, i.e. take lower ranking position again and again, still troubles too difficult to just apply. I'm not sure what this means. If you're struggling at work and you've been accommodated and the doctor supports that you should go off work, then by all means go off work and apply for LTD benefits. If this is an employment question, by all means reach out to our firm and speak to one of our employment lawyers. We're in a very fortunate position at our firm because we have people dealing with disability cases and we have people dealing with employment cases, which often overlap. But I would be more comfortable if you pose that question to an employment lawyer. There's a question on Facebook from Brad. My doctor is refusing to release my medical notes to my insurance company or me. I'm now being cut off as a result. What should I do? That's a very unfortunate position to be in. Your doctor has to release those records. You've provided a consent. I would put it in writing as well that the doctor must release the records within a certain period of time. Make known to the doctor that as a direct result of the doctor refusing to provide the records, your records, to the insurer, that you are now being prejudiced and financially because they are denying your claim. So put that in writing, send it to the doctor, and if the doctor refuses to provide it, then maybe you can report the doctor to the governing authority. I'm not saying that is what should happen, but maybe consider proceeding on that basis. Also, if maybe getting somebody else involved to write a letter to the doctor to explain why it is so crucial that it is required, and maybe have the insurance company provide you with a letter which you can then submit to the doctor as well, saying this is what is happening as a direct consequence of you not being provided, or because of you not providing the records. We have a question on Reddit from Hobesk. Hobesk? I've been off on disability for the last year due to stress and anxiety. I'm considering a return to work. I don't know if I can go back to the same employer. Would resigning from my position impact my LTD? This is a difficult question. I'm not saying this is what happened, but reading in between the lines. So if there is a situation where a person goes off work because of a toxic workplace, and they then feel that they are ready to return to work, but not to that employer, the insurance company is going to look at that as, well, this is a workplace issue, it's not a disability issue, which means then that they may deny the claim. When you submit a claim for LTD benefits under a policy, the definition is, and I have this discussion with people on a weekly basis because there's so much of this out there. The definition for LTD, for total disability, is you must provide evidence to support that you cannot perform the duties of your own occupation. Occupation, not job. So if you say, I'm able to go back to work because I was bullied and harassed at this workplace, but I can go somewhere else where the bully is not present, you may not meet the definition for total disability because the insurance company will look at that as, this is a workplace issue. You're able to perform the duties of your occupation, just not at this place of employment, and that's not our problem. So be very careful as to how you proceed here. If your doctor supports that you can return to work, consider how that is going to be phrased when you report that to the insurance company. But for many people, this is a very difficult time. People get denied at the outset quite often with disability cases. And the reason why is the insurance company will say, well, you're able to work somewhere else. And our position on this, and my client's position on this, usually would be, well, the damage has already been done. I now first need to be treated in order to be able to go back to work. So, yes, it happened at this workplace, but it now prevents me from going back to work at any workplace because I need to be treated with respect to the disability that has resulted from the workplace issues. So that's the way I think to phrase things. But if you are able to go back to work, then you may not qualify for benefits. Then in 2006 says, after termination, can I apply for mental disorder compensation due to bullying during employment? Exhibited insomnia and panic attacks during work, have a psychiatrist report after termination. Okay, so if you say, can you apply for mental disorder compensation due to bullying during employment? That, if you're asking about a human rights complaint where you may pursue damages, again, contact our firm and speak to one of the employment lawyers. If it is that you were disabled during the period that you had coverage and you were struggling at work, unable to perform your duties even though you were showing up, that's a more difficult claim. But if the doctor, the psychiatrist that you have supports that you were disabled from performing your duties while you still had coverage, then you may want to consider submitting a disability claim. To be clear about this, these things are quite difficult. When you submit a claim for disability benefits, you must have coverage. In other words, while you are employed actively at work, you have coverage. If your employment terminates, you no longer have coverage. If you become disabled after the termination, you likely won't qualify for benefits. If it is, I was terminated because of my disability, then you may have a claim to pursue and submit it to the insurance company by, I'll use an example, if somebody has, coming back to it, they've got anxiety and depression, they're struggling, they're making mistakes, they have anxiety attacks at work, they miss deadlines, they cannot perform their duties, yet they are showing up, and the employer terminates them because of poor workplace performance. Clearly, in that scenario, I would say that the person continued to struggle. The fact that they made mistakes shows that they were unable to perform their duties, and when the employer terminated their employment, even though coverage ended, they should have made a claim earlier on. As I say, these are more difficult cases to argue, but it does not mean that you should not submit a claim if you have that evidence and if that is what happened. And if the claim is denied, again, sound like a broken record, reach out to our firm and we can review your circumstances with the denial letter with you and then provide you our opinion as to what your options are so you can make an informed decision. Liz says, the question came out poorly. New disability diagnosis. Work won't talk about accommodation, not on LTD yet. Okay. If the situation is that you are struggling now because of a new diagnosis and work will not accommodate you, you really have to have a discussion with your doctor. Because if the doctor says you cannot perform your duties, she also says epilepsy, if it makes a difference, can be workable with accommodation, right? Well, I don't know. It really depends on your circumstances. So if have a discussion, what I would do is I would go have a discussion with my doctor. If you have epilepsy, in other words, if it's well controlled, well, then maybe you can perform your duties. And if the employer is not accommodating you, then that may be a claim against the employer with respect to some constructive dismissal situation. But again, on that front, you should speak to an employment lawyer. If it is that the epilepsy is new, it's not controlled, and you may have epileptic attacks at work, which may impact your ability to perform your duties of your occupation, not your job, your occupation. Have the discussion with the doctor as to what should be done. If you are at risk of injury or injuring others or putting others in danger, it depends on what type of work you do because of epileptic attacks, then consider whether a disability claim should be filed, submitted to the insurance company. When you have a claim for disability benefits, or you're considering to go off work, crucial, always, to have a discussion with the doctor whether the doctor supports that you are unable to perform the duties of your occupation. With respect to a diagnosis like this, I have seen cases where the insurance company says, well, you're on medication, it is being controlled, so we don't think that there is a disability. But I've also seen cases like this where the person may have episodes now and again, but they may be operating heavy machinery. So when they do have one of those attacks, it is life-threatening, not just for themselves, but also for others. So you have to consider what are your duties, what are your restrictions and limitations, regardless of what the diagnosis is. And most importantly, have the discussion with the doctor to see whether the doctor supports that you cannot work. And again, if there is an accommodation issue, speak to an employment lawyer as to what should be done. Because they can give you advice, right? There are various things I think that you can do in a situation like that. So, long story short, speak to the doctor. If you cannot perform your duties, consider submitting a claim, or contact us to speak to an employment lawyer if the employer is refusing to accommodate you. And as you can see on the screen, again, go to disabilityrights.ca for more information. Question from Art on Facebook. I was recently in a serious accident and suffered a brain injury. I will have long-term impairment. When should I speak with the lawyer about the accident? Do I need separate lawyers for accident and LTD? I think what you should do is speak to a lawyer immediately. It depends on where this happened, of course, and which province you live in. I think can a lawyer who handles the LTD case handle the accident claim as well? It depends on what the lawyer, whoever you contact, whether they're able to handle both. It's interesting to speak about this because long-term disability benefits all pay pursuant to policies, and these policies have, as I said before, rights and obligations and offsets. If you have a car accident where you say there's long-term impairment, which I assume means that you cannot work. If you also ask about the LTD, if that claim for personal injury is pursued, I assume that you will be making a claim for wage loss and even long-term loss of any capacity. Most, if not all, group policies do provide that if you have a claim against another entity, another person or a third party, an insurer, for example, for wage loss due to this, and this entity caused your disability, then the insurance company must say that they are subrogated. In other words, they can step into your shoes and recover the money that you may be paid through that action. So to put it in simple terms, if you have a claim against the person who caused the car accident and you get a settlement there, and that settlement includes wage loss for the same period of time that the insurance company paid you benefits, then the insurance company will say, we have a right to recover that money from that settlement because we didn't cause this, and otherwise you would be doubly compensated. In other words, they paid you long-term disability benefits for the same period, and you received wage loss damages, if you want to call it that, for the same period, which puts you in a better financial position. So most of these policies have that wording in it. I would wonder if a lawyer, I've seen this happen before, that lawyers do handle both of them, but you have to be cognizant of that feature of the claim. And also make sure that you do find somebody who's qualified to handle both, and people who don't just dabble in these areas, but actually have experience in handling them, because there's a fine line, and you have to figure out exactly how to approach this, considering that there may be a bit of friction between these two. Okay. Liz says that's good advice. Thanks, appreciate this confirmation. You're very welcome, Liz. I wish you all the best and I hope this works out for you. Friend P says, as the top Canadian executive, if my doctor recommends stress leave and the company owner is in the US, is advance notice mandatory, the company lacking a ready replacement? Okay, so this again sounds like an employment issue, which I suggest that you do speak to one of our employment lawyers. But with respect to a disability claim, if the doctor recommends that you go off work, in other words, and I would be very careful how this is worded, because as a top Canadian executive, the doctor recommends you go on stress leave, and the owner is in the US. If your doctor recommends that you should stop work, I would think you should follow your doctor's advice. But be very careful how this claim is submitted, because if it is going to be on the basis that there's too much stress at this location or with this employer, remember what I said earlier on, you may face a denial. What you have to submit evidence of is that you are unable to perform the duties of your occupation due to an illness or a condition, which in your case may be an anxiety disorder. I'm not a doctor, but your doctor would have to make sure that the doctor gives a proper diagnosis and then detail what the restrictions and limitations are. And in your case, it's not going to be enough to just say, my patient has a lot of anxiety and stress and they should stop working. I would suggest that your doctor puts into context why it is that you cannot work. As a top Canadian executive, clearly that is a position that requires, I would think, a lot of multitasking. It would be fast-paced, it would be very stressful, you would have to manage people, you would have to manage projects, and how is your medical condition impacting your ability to perform those duties? What are your restrictions and limitations? In other words, if you have panic attacks, or if you cannot sleep, you've got insomnia, or if you're taking medications that affect your cognitive functioning, all of these things need to be detailed in hopes of having this claim approved. And of course, if it is denied, by all means, reach out to us. But with respect to the question that you have, the mandatory, is advance notice mandatory? I don't think if you have a medical condition and the doctor says you need to stop working, I don't think you can be fired. Well, I suppose they can still do this, but I think then you may have a claim based on human rights, human rights complaint at least, with respect to this. But I should not weigh into employment issues. Speak to an employment lawyer about this as well. Thank you, everybody, for all the questions. We've gone a little bit over time. We'll do this again. If you enjoyed today's session, please go ahead and like it. Next session will be join us again live at 12 p.m. Let me just see. This is on Thursday, October the 19th, with Alex Lucifero. an employment partner at our firm at 12 p.m. Eastern Standard Time with respect to questions on employment and disability, which I think is awesome because that will be an overlap between what we've just discussed. So many of these questions, please post them there as well, because then you have the benefit of having the input from an employment word and potentially from a disability angle as well. So again, thanks for joining us and all the best.